Time now for Night Courts. Tonight, we're looking at a lawsuit filed by Dairy Queen against W.B. Mason, claiming the Massachusetts office supplies company's use of the name Blizzard for its bottled spring water is a case of trademark infringement on DQ's popular ice cream treat and unfair competition. So let's start a food fight for a food court argument with tonight's legal eagles, class action attorney Kelly Hyman and criminal defense attorney David Bruno. And for the record, my team and I thought it was very important to do some field research tonight. So I have researched the Mocha Oreo Blizzard, and I can tell you it's delicious, but that will not bias me in this case. So let's start here with Exhibit A. This is from the Star Tribune reporting on the lawsuit. It says Dairy Queen is suing W.B. Mason, alleging its bottled spring water bearing the name Blizzard is a trademark infringement on fair competition. The soft serve ice cream blended with fruit, nuts, candies, or other flavorings is required at all DQ locations, and the company notes that its stores also sell water. Kelly.
Well, they're going to argue that this is different because of the fact that people see the water. They're not going to associate it with Dairy Queen. It's a totally different company. It's been around for many years. And because of that, it's not similar to Dairy Queen's product. And therefore, they're not infringing on their trademark.
Okay, let's get to Exhibit B then. This is from the W.B. Mason counter lawsuit. They say it's not aware of a single person who has ever been confused by its use of Blizzard. Indeed, no reasonable person would ever mistakenly believe that copy paper or spring water sold by W.B. Mason and emblazoned with the W.B. Mason mark and logo emanates from or is associated with Dairy Queen. David?
Yeah, it's confusing, and I disagree with W.B. Mason. I mean, essentially, the Dairy Queen has these 5 trademarks that fall under the protection, the Federal Trademark Act of 1946. And their first trademark was in 1952, and as recent as 2011. And the reason why it's so confusing is that W.B. Mason does not just sell office supplies. They also sell Dunkin' Donuts, Coca-Cola, Pepsi, Tropicana, Mott's, Special K, a lot of other name brands. So if it were just selling the Blizzard water and not these other name brands, it wouldn't be as misleading and confusing. And Dairy Queen has worked very hard for the trademarks and also their brand. I mean, they have over 4 million people in their fan club, just to say the least.
Almost
so
as many
they've worked so hard for the brand, and now W.B. Mason is trying to take advantage of it through their water
I don't think
service.
that I can get this from an office supply store. I don't know. I'm going to keep researching, so we'll see. Exhibit C, also Dairy Queen says this. They, as David noted, were first introduced to the public, the Blizzards, in 1946. By the way, the year my mom was born, a very good year for things to be born. W.B. Mason's infringing conduct is causing and likely to cause injury to the public, and I'm not sure how that happens, but also causing and likely to cause Dairy Queen to suffer irreparable injury. Kelly.
Well, ultimately, Shannon, as you know, the court will make a determination based on the evidence of whether, in fact, there is an infringement and it is harming Dairy Queen. And we're going to have to see how this turns out in court.
We will, which takes us to Exhibit D. This is also from W.B. Mason's counter lawsuit. They say, as used in commerce, W.B. Mason's use of Blizzard is not similar, and indeed is substantially different in sight, sound, and appearance, and is fundamentally different in commercial context from any Blizzard mark registered or used by Dairy Queen. It's bottled water, David.
Sure, it's going to be the position of W.B. Mason. I mean, without a doubt. But like I said before, it's a little misleading because there are other brands. And Blizzard clearly is the ice cream of Dairy Queen. There's 2 issues, whether or not they could continue to sell it, and then there's issues of damages. I think damages are going to be tough to come by if they get to it. I think it's more likely that there's going to be a settlement here because the lawyers for W.B. Mason have already said after this recent ruling by the district court, they're going to look at their legal options. And when you lose motions like they have, typically they go to the settlement and they work it out outside the court.
All right, we will continue our in-depth research on the Dairy Queen Blizzard situation and keep everyone updated on the case. Kelly and David, thank you. Always great to see you too.
Thank you, Shannon.
You as well.